In this case, the employee, a full-time school bus driver, drove students to a school-sponsored skiing event. She received a free ticket to ski while off duty. While skiing, she fell down and sustained a torn ligament and a blood clot in her leg. She drove the students home but was later forced to miss work. She applied for workers' compensation from her employer. How would you decide this case? Is an employer required to pay workers' compensation benefits to an employee who was injured in a non-work related activity? We'll be back in a moment with the answer to that question. Is an employer required to pay workers' compensation benefits to an employee who is injured in a non-work related activity? No, according to the South Dakota Supreme Court in this recent opinion. According to the court, an employer will not be forced to pay workers' compensation benefits to an employee that takes part in an activity that they would not be reasonably expected to do. Also, an employer will not be forced to pay workers' compensation benefits to an employee if the employee cannot prove that the activity being performed when the injury occurred relates to the employment. This case involves an employee's rights under South Dakota's workers' compensation laws. To recover under workers' compensation, a claimant must prove by a preponderance of the evidence that she sustained an injury arising out of and in the course of her employment. In order for an injury to arise out of employment, the employee must show that there is a causal connection between the injury and the employment. The workers' compensation scheme also requires that the claimant prove that the employment was a major contributing cause of the injury. Remember, it's a matter of law.